Hi, David. I thought I would try this differently than we have in the past. I've just come back from a review of the Whitner Spiewak firm in St. Louis, Missouri. This is a firm that had one major claim involving estates and trusts, a matter that went completely south, and then it has another largish claim related to personal injury matter that one of the associates who is no longer there has handled, where he basically missed the filing because he didn't understand the difference in jurisdictions. Whitner is the senior guy in the firm, and basically it's his. He's the patriarch. There are two of his sons who work in the firm, one who does criminal defense and another who's involved with the business, of which another of the associates is a member, and they own that business. It's a third-party medical insurance claims and defense practice, not practice, but a business. And the firm does work for this company, and these guys are owners in it. It's called Midwest Medical Litigation. It's a general practice firm. They cover a lot of practice areas. There's estates and trusts that he does. He also does family law. They've done some real estate in the past. They do a lot of business representation. Malak is a person who has a tax background, so some of the work comes to them because of her specialty. But it's a combination of litigation and transaction work. The firm is completely informal in its construct. The firm could have existed just exactly as it does today in 1970. There's virtually no difference whatsoever. He started the firm, in fact, in 1978, and there's been some iterations, but essentially it's the same firm. There isn't much in the way of oversight of individual practices, although the firm is comfortable and they meet regularly for lunch. They don't have any kind of a formalized setting, and in fact there's no real formal structure to the firm. The other partner that I worked through, Mr. Spiewak, is kind of the administrative partner, but the decisions are all made by the partners individually, by the shareholders, I should say. So it's a very standard kind of report. They don't have much in the way of structure when it comes to case acceptance, but they have, I think, come to believe that that's a good idea. And according to them, they're making efforts in that direction. Of course, my report focuses on that kind of thing. Their fee agreements are lackadaisical and need to have some real change, and of course I've given them all that kind of information. The conflicts, they don't handle particularly well. They rely pretty much on the way that lawyers have done it for those 40 years, which is to remember whether or not they've worked for a particular client. They don't have a robust lookup table of any kind, and of course all that admonition is included in the section on conflicts. Countering isn't really much better. Countering is done about as informally as it could be. Receptionist takes the materials and she passes them out to the lawyers. So the lawyers get the materials before they get docketed, which is a bad thing. And so I'm hoping that they'll make some changes there. Of course, the section on firm meetings stresses the need for them to have a formalized meeting schedule where they talk about cases in a formalized setting, and they talk about the progress of the various cases, and that of course goes into the case reporting system section, which you've seen before. As you have also seen lateral hire section, they don't have any process for doing that. They don't have really any kind of processes in place to do much of anything that is anything other than just the informal way. So it's not an unusual firm in terms of their ability to stay out of difficulty. I think you could admit or agree that the estates and trust matter came unglued for lots of different reasons, but there's no reason to believe that it might not happen again. There are no strictures in place that would keep that from happening. They still do personal injury. They don't have the kind of oversight I'd like to see when they do that kind of thing. and I'm hoping that's one of the changes they made. They had the criminal defense lawyer, who happens to be Whitner's son. He does that work by himself, and there isn't any, as far as I can tell, other than, again, informally done. There's no oversight of that practice. So that's the story with the firm. The report is being generated. I'm writing it now. It'll be pretty standard, and you've seen this kind of thing before. So let me know what you think of this. Perhaps it takes more time than you want to take on it, but at least it's a shot. So let me know what you think.